Well, thank you everyone for coming this afternoon for our annual planning CPD, which is conducted by myself, Matt Harker, and Michael Astill, who's here to my right. For those viewing from home, if you're not familiar with Michael already, you'll see him very shortly. So today we're talking about what has become a very topical issue, which is contamination and specifically asbestos. Unfortunately, we are not going to talk about the big mess that is Rozelle, because that's still in a very early stage and there's no judgments or proceedings yet. I can see some smiles at the back of the court from those who are potentially involved. But what we're going to look at specifically is a series of cases in the Wallandilly Shire involving a company known as Muscat Proprietary Limited. Now, there's a series of cases, and both in Class 4 and in Class 1 of the Land and Environment Court involving this company and the council. And I'll give you a brief overview of those, and specifically one particular development application and a decision which ultimately was appealed to the Chief Judge of the Land and Environment Court. So firstly, we'll give you an overview of the Muscat litigation, then talk about the potential interrelationship between the Protection of the Environment Operations Act, which deals with waste and land pollution specifically, and also the Environmental Planning and Assessment Act. Then we'll look at the Chief Judge's decision in Muscat Developments Proprietary Limited and Wallandilly Shire Council. And finally, and the big question that essentially overhangs all of this presentation is, why would you seek development consent for work that is unlawful, specifically under another statutory instrument? So, to the never-ending Muscat litigation. Just to give you a bit of an overview, this slide deals with this particular case involving a property at Corder Road. This company owns a lot of property in the Wallandilly Shire, and council has uncovered evidence at a number of sites that there was a significant amount of fill that had been deposited, and that fill contains asbestos and also hydrocarbons. And it's common ground throughout all this litigation, at least in the Class 1 space, that this fill was brought onto the site without either an approval under the EPA Act or a license, Environment Protection License under the POEO Act. So it was unlawful. And we're talking a significant amount of fill here. To give you an example, Michael and I were involved in one case where we acted for the council, and it was quite a good piece of advocacy on Michael's part. He stood on a mound that was 7 metres above the existing ground level, and he asked the expert, so the existing ground level is 7 metres below here? The answer was yes. And he said, and you're proposing to make it 7 metres higher. So we're talking about 14 metres of fill at that one location and a serious amount of cubic metres. It wasn't so much different in Caudle Road, which is the case that we're going to talk about here. In essence, on this site, there were 6 existing sheds, some of which were used for the purposes of poultry farm, 3 dwellings, the poultry farm that I referred to, and there are at least 2 mounds of fill that were unlawfully placed on the site and contained asbestos and hydrocarbons. Now, the applicant took an interesting approach to deal with the remediation, because the council commenced Class 4 proceedings, essentially requiring them to clean up and remove the asbestos. And there was ultimately an agreement which gave the context of the Class 1 proceedings that if they did not get development consent, they would be required to remediate the site and remove the fill. Now, what they did in the development application was to seek consent not for the fill because you can't get consent for works that have already been carried out, but instead sought consent to the use of the mounds for the purposes of the poultry farm. And the basis for that was that the mounds would provide a shield for visual impact, and they also can commonly be used as a barrier in terms of acoustic impact as well. So they proposed that also, and I'm working from the bottom up, which is probably not wise, remediation work to the mounds, construction of a new farm building for the poultry farm, and also change of use to some of the sheds away from the poultry use to use as a depot. So really the two ones that we're focusing on are the bottom two here, the remediation work and the consent to use the mounds for the purposes of the poultry farm. Just to give you a sense of what we're talking about here, here is a plan submitted in the Class 1 proceedings. When the poultry farm, consent was given to the poultry farm, the council did also grant consent to some mounds. Those mounds are shown in red. There's also, as you'll see, a large amount of fill that goes beyond what is in red. In blue is mounds containing unlawful fill that were proposed to be reworked and reshaped and capped. And then in green is also mounds of unlawful fill, which were largely intended not to be reworked, reshaped, but merely landscaped. So we're dealing with, just looking objectively there, at a significant amount of fill, a large portion of which, or there was evidence, contained asbestos. Now, how is the Protection of the Environment Operations Act relevant in these proceedings? So it wasn't integrated development, they didn't tick the box, therefore there was no need for the council to send the DA to the EPA and to get general terms of approval in relation to an environment protection licence. There was, however, a question as to whether the work in order to remediate would be a breach of two provisions of the POEO Act. And I'll take you to those shortly. But in essence, council argued that the remediation would be unlawful under section 142A and 144AB of the POEO Act. And as a result, development consent should not be granted in order to sanction an unlawful activity. Now, what's an interesting point for later, there is a suggestion in Chief Justice Preston's judgment that this contention was framed by the council not as a should not, but as a must not or a cannot, which is that court doesn't have jurisdiction in those circumstances to grant consent. The Chief Judge took significant issue with that, as you'll see, and it was potentially the downfall of the council on appeal. Turning to 142A, it's a really, really simple provision. And it's just the person who pollutes land is guilty of offence. And pollute land, the definition there doesn't really add anything other than potentially expand the definition to include someone who permits land to be polluted. But some more insight is provided in the definitions in terms of what pollution of land means. In essence, and looking at A, that's probably the most relevant one, it's the introduction of any matter, whether solid, liquid or gaseous, that causes or is likely to cause degradation of the land, resulting in actual or potential harm to the health or safety of human beings, animals or other terrestrial life or ecosystems, and so on. So you might ask the question, how can remediation of contaminated land fall within that definition and be pollution? Usually you'd think it wouldn't, but in the circumstances of this case, where the proposal was in essence to spread around and rework the fill as part of the remediation, the court ultimately held, at first instance, Commissioner Bish, that this would degrade the land because you're in essence moving asbestos to parts of the site which did not previously have asbestos on it. And also that work and that movement would cause actual or potential harm by exposing residents and workers to the land to potential asbestos contamination. And as I said, that was ultimately accepted by the Commissioner at first instance, and what is an interesting comment. She essentially held that because it's in breach of the Act, it wouldn't be in the public, in breach of the POEO Act, it wouldn't be in the public interest to grant development consent to the remediation works. The other provision that the council relied upon was section 144 AAB, which deals with the reuse of asbestos waste. Somewhat unhelpfully, reuse is not defined in the POEO Act nor elsewhere, and that has left us in a position where there are actually two divergent judgments of commissioners of the court dealing with what reuse means. The first was, again, another Muscat matter, a decision of Commissioner Clay, where the Commissioner rejected a submission from the council that reuse means what you ordinarily think it means, of using something again for a second time, which is consistent with the natural and ordinary meaning. But Commissioner said, considering it in context, that what the provision was directed to is an advantageous second use of asbestos waste rather than its remediation. And he pointed out the absurdity of the fact that if it was simply a use again, if reuse would mean a use again, then any remediation could conceivably result in the commission of an offence. And part of the objects of the POEO Act are obviously to avoid contamination and minimise degradation to the environment. Remediation generally being something that would be consistent with those objects. So there's potentially some merit there, although advantageous second use is a phrase and a concept that is completely foreign to the POEO Act. So there could be a suggestion that there is a little bit of reading words in here. And that seems to have been latched upon by Commissioner Bitch in the Coral Road litigation, which was the plan that I showed, related to the plan that I showed you before. And the Commissioner there expressly disagreed with the approach of Commissioner Clay. She refers to the council's proposition that reuse means what you'd ordinarily think it means, which is to use again or more than once, and therefore by reshaping or reworking of the existing unauthorised fill, that is a reuse of asbestos waste. And she ultimately relied upon that as is consistent with the ordinary, accepted that as consistent with the ordinary meaning of the words. Curiously says there's no evidence that makes a distinction of asbestos use having to be for advantageous second use, but presumably the Commissioner there is referring to there's no suggestion in the Act that this advantageous second use concept should be adopted. So there's that tension there which, as we'll see, wasn't actually resolved on appeal. So in terms of the relationship between the POEO Act and the EPA Act, just a few truisms. Firstly, consent or approval under the EPA Act does not mean you don't need a licence under the POEO Act. Rozelle is a good example of that. The department presumably carried out the works for the Rozelle interchange pursuant to a Part 5 approval under the EPA Act. And yet they have been hit with a notice under the POEO Act requiring the clean-up of asbestos waste that is contained within the mulch at the interchange. And similarly, the converse is also true. If, for example, the transport got a licence to deposit asbestos at the Rozelle interchange. I mean, you struggle to see any world where that would happen. That doesn't mean that they didn't need consent or an approval under Part 5 of the PNA Act. There's two separate regimes that operate concurrently, and that's reflected in Section 7 of the POEO Act, which makes abundantly clear that nothing in this Act affects any of the provisions of any other Act or any of the statutory rules, or takes away any powers vested in any person or body in another Act. So you have these two operating in parallel, but how can they work together? And one example is Section 39(4) of the Land and Environment Court Act, which says that in making its decision in relation, this is a really useful provision. If you ever are faced with an argument that somebody says it's not in your contentions, why should I not consider it? The court's bound to consider the public interest, and it's also bound to consider any other relevant act or instrument remained under any relevant act, which in this case, in the court of litigation, would include the POEO Act in circumstances where a licence would be required. As we've seen, the Commissioner determined that the moving around of the fill and the asbestos would be a breach of the POEO Act and unlawful, giving rise to criminal sanction. There's also Section 4.15 of the PNA Act, which requires the consideration of the public interest, which raises a series of questions. If the court were to grant consent to an unlawful activity under the POEO Act, how can that ever be in the public interest? And if it's never in the public interest, what is the utility of the grant of consent? And I think there's a very strong argument to be had there, and there's certainly an argument that swayed Commissioner Bish in the court of litigation, that if she were to grant consent, she was in essence just setting the applicant up to fail, because if they were to carry out the development, they would be in breach of the POEO Act, and that would be unlawful and they'd be exposed to criminal sanctions. So it's in essence granting consent to something that could never properly be carried out. And the third question is, what about coherence in the law? And that's a big thing in the common law. You can see in terms of issues of duty of care, that the court talks regularly about the need for coherence in the law. That's kind of it's been skirted around in the statutory context, but here's a good example where, through consideration of the public interest, that two acts, at least the POEO Act, can be considered, and probably in my submission should be considered, when determining whether or not to grant consent under the PNA Act. But ultimately, the Chief Judge in the Land Environment Court had some things to say about that, particularly in the context of jurisdiction in the Caudle Road case. And I'll just hand over to Michael now, who will run you through that.
Thanks, Matt. I just don't want it to be misleading that these three questions are about to be answered by they're posed and work out from what I say, and as we go through this case, the extent to which they remain outstanding questions, outstanding in the sense that they're not dealt with as opposed to they're really good questions. All right, so the decision of Commissioner Bish was taken on appeal under Section 56A on an error of law, and there were 27 grounds in the notice of appeal, which were, on hearing, condensed down to 27 grounds. Justice Preston grouped them, and the group that we are concerned with, I forget what group that was, I think it was group 3 or 4. Anyway, it's grounds 11 to 15. 11, we don't need to delay with. I mean, I think the submission was that not following another commissioner's decision as a matter of comedy isn't really an error of law as such. So we don't need to spend much time on that. And as Matt said, the nub of this really is 12, which was that the Commissioner erred in accepting the court could not, that is in the sense of legal power, could not grant development consent for works that would amount to criminal activity under the POEO Act. Ground 13, which was the reuse, the remediation was a reuse, and that's the divergence of opinion between Acting Commissioner Clay and Commissioner Bish about what reuse means. Grant 14's in similar vein well, it's in similar vein to that really, whether it was polluting land and misdirected herself generally. So in considering Grant 12, which was the could not, or the jurisdictional point, this is Justice Preston's words, the Council had contended and the Commissioner accepted that whether the proposed on-site remediation of asbestos waste by reworking is lawful under the POEO Act was a jurisdictional requirement for the grant of development consent. These 1 and 2 aren't actually the paragraph numbers. I think that's just automatic paragraph numbers. The paragraph numbers are referred to in brackets at the end of 152. Preston Jays then says, I find the Commissioner did err in her consideration of the provisions of the POEO Act by asking herself the wrong questions. The Commissioner was entitled, at least by 39(4) of the Court Act, to have regard to the POEO Act. In fact, arguably not entitled but required in making a decision in respect to the appeal as to whether to grant or refuse consent to muskets. GA, the issue was how the Commissioner could have regard to the POEO Act. It's interesting the way Justice Preston frames all of this. We know, of course, that one's not meant to review decisions of commissioners with a fine-tooth comb and with a mind finely attuned to error. So I'll just leave that there. Justice Preston then says or finds that the Commissioner set up the issue as one of jurisdiction. He says she framed her consideration of the Act, the POEO Act, in terms of jurisdiction. He says whatever was the prompt, the Commissioner understood that the lawfulness of the proposed remediation works was a jurisdictional consideration of the Court. The Commissioner entitled a part of her reasons for judgment as jurisdictional requirements, and the first jurisdictional requirements she referred to in this part were those provisions of the POEO Act. She first put aside any consideration of the lawfulness of the original placement of the unauthorised fill. She accepted that is not the jurisdictional test in consideration of the amended application before the Court. Rather, the jurisdictional test, this is Justice Preston quoting her, in consideration of the development application was whether the proposed on-site working of asbestos waste was lawful under those provisions. By framing the question as jurisdictional, the Commissioner asked herself the wrong question. An alternate way that her judgment might have been read was that she is not a lawyer, has never been a lawyer, and uses the word jurisdictional in not a legal sense. But again, I'll leave that alone. Justice Preston then, having set up proposition that she's in the area of jurisdictional requirements, strictly so-called as lawyers understand that to be, he then goes on to find that, poses the question, why was that an error, if he found it was an error already. And the 3 points, which really must be correct, whatever Commissioner Bish did, these points come out of what Justice Preston said, irrespective of anything about fine-tooth combs of the like. The parent section 4.16 of the Planning Act to determine development application seeking consent for remediation works is not conditioned on the lawfulness of the remediation works under the POEO Act. In other words, forget it if it's illegal, completely illegal. It's not conditioned. The grant of consent is not conditioned. Secondly, the jurisdictional requirements for the determination of such DAs are to be found only in the EPA Act and the regulations and instruments made under that Act. And the POEO Act does not fix any jurisdictional requirement for the determination of such a development application under the EPA Act. And of course, as we've already seen with respect to the last point, Matt's already referred to on an earlier slide, Section 7 of the POEO Act, which expressly says that that Act does not have any limiting effect on a person doing something under any other Act. So that's no doubt correct. So the consequences are set out in this slide. The second point is what I really read on the earlier slide. Each statutory scheme is a completely separate process for making and determining DAs on the one hand and obtaining environment protection licences on the other, and each statutory scheme operates independently from the other statutory schemes. We haven't in this talk sought to talk about integrated development applications where, of course, you can, in a DA process, introduce a POEO Act licence issue and then go off to court to try and obtain effectively both at once. Not oversimplifying it, as you all know, but we haven't delved into that area. But apart from that, each statutory scheme is independent of the other. Of course, on an appeal on a question of law, any question or any error must be found to be material before the decision is vitiated. Justice Preston said this: the consideration and findings under one statutory regime shaped the consideration and findings under another statutory regime. For example, the Commissioner's findings on the proposed reworking of the mounds of unauthorised fill containing asbestos waste to form new mounds when addressing the provisions of sections 3, 142A and 144AAB influenced the Commissioner's consideration of and findings on the provisions of the SEP resilience, especially sections 4.6 and 4.10, and both the consideration and findings on the POEO Act and SEP resilience influenced the Commissioner's consideration and findings on 4.15 of the Planning Act and the various clauses of the LEP. So he's effectively found that this group of issues, 11 through 15, I think they were, reflected an error of law. He then goes on to find that the way she approached those issues effectively, well, he uses the word influenced, but effectively infected the way she dealt with the whole application. And so, unsurprisingly, he upheld the appeal. I don't know whether it was necessary for him to really find that the whole judgment was infected by those grounds. It would seem that she clearly found that as a matter of jurisdiction, she had no power to approve the application, and that I would have thought would have been enough. But anyway, Justice Preston, if you're interested in all those other grounds, obviously you can go have a look at the judgment at your leisure.
It's a long read.
It's a long read, Matt warns. So where does that leave us? And I think these are the outstanding questions. How can unlawfulness under another capital A Act ever be taken into account? And what is reuse of asbestos waste? We can perhaps make some comments about the first of those questions. So unlawfulness clearly should not be framed as a jurisdictional question, but whether conduct is lawful under another statute can be introduced, as Matt I think said earlier. 4.15 introduces public interest considerations, and 39.4 of the Court Act. I think there's a slight typo there. It's 4.15 of the EPA Act and 39.4 of the Court Act. But you understand what we're talking about. There's a reference there to an earlier, quite early for most of you weren't born in 1993, but not that early for me. McDougall and Warringah. It was an interesting case, if not for the reason that it was to do with control and regulation of keeping of pigeons at Wheeler Heights, which is a suburb on the Northern Beaches that some of you might have been aware of. And the council had controlled and regulated to prohibit pigeons keeping on a particular property, and then they put in a DA for a pigeon house. And so it was a very interesting interaction of all of that. And anyway, the Court of Appeal said, I suppose consistently with what Justice Preston's held that one does not stop the other. So the mere fact that the council had already controlled and regulated pigeon keeping so as to make that unlawful did not proscribe the grant of development consent for a pigeon house, but that circumstance could be relevant to the merit question of whether or not development consent should be granted. So that's what Justice Cripps, Judge of Appeal at that point, not Land and Environment Court judge, said, and the other judges, I forget who it was, doesn't really matter. Kirby, President Kirby as he then was, and I think it was Marnie was the third judge. So the question 3, which is interesting, that is, even if you don't frame these issues in the Land and Environment Court appeal on why development consent shouldn't be granted, maybe you just, it doesn't matter, you let the consent be granted and then rely on other illegality to stop it. But the question posed there is, why bother granting consent to something that is otherwise illegal? And I don't know what the answer to that is. The other question that arose before both Commissioner Clay and Commissioner Bish was, what is reuse of asbestos? What does that mean? Is it an advantageous second use, or is it just using it? Does say you've got asbestos and you want to use it as a building platform, is that reuse? The two commissioners have quite different views about all this, and Justice Preston didn't wade into that debate at all. So, because I guess he didn't have to, his view was, I suppose, even if it is unlawful, it's not a relevant consideration in the development application arena. So that's the last slide. And so we would throw to questions. Either there's questions, no questions online? No questions online. Any questions in the room? You've been given paddles with numbers on them, I think.
I suppose the question on reuse of asbestos waste and the interpretation of the EPA, I think, is sometimes what guides these things rather than necessarily any ventilation. I wish Justice Preston had expressed a view on this, but I guess it doesn't make sense to me for it to be read as an advantageous second use, because that kind of leaves the suggestion that an inadvertent or rather unconsidered second use that was not necessarily intended to be advantageous doesn't get caught by that provision.
Yeah, it introduced a sort of subjectivity to the whole analysis.
That's not how, just coming to mind, like graphel, and, you know, if you'd imported that kind of logic onto graphel and, you know, the consequences of what should have been done with the mounds of infected asbestos waste, that doesn't really bring in that requirement for it to be an advantageous second use.
Yeah, I agree.
Well, the intent of those provisions is pretty clear. That is, if you've got asbestos waste, there's only one place it's got to go, and that is a controlled waste landfill. But it doesn't contemplate what happens if someone does something else and puts it in illegally in the ground. What do you do then?
Or inadvertently indulge.
Well, yeah. I still don't know how that got into the mulch, do we? The suppliers denying it all, and no one seems to know. But do you have a comment on that?
No, I think it's a really good point. Those words are just completely foreign to the Act, and that's usually a strong reason not to read them in. So I intend to agree as purely a matter of construction with what Commissioner Bish found. And it's a bit unfortunate that the Chief Judge didn't weigh in, because it would settle it not only for proceedings like these, but also future criminal proceedings in terms of reuse.
Yeah, no, just playing that forward. If you can't reuse it in the way that Muscat was proposing, and you can't get development consent, not as a jurisdictional matter, but as a matter of merit, then I suppose the end result of all that is there's only one thing that can happen to that asbestos waste, and that is you dig it up and you take it to a licensed landfill, and that's not a ridiculous proposition. It may in certain circumstances be impractical and expensive, but lots of things are impractical and expensive. But you shouldn't have had asbestos waste on you, and you shouldn't have had asbestos waste on your land in the first place is the obvious answer. I mean, that's an obtuse thing to say, because in a lot of cases, some of you and I have acted for innocent landowners who, are sold a pup by people who say, I'm bringing in clean fill, and they bring in everything but clean fill, and then disappear. So you're left with a sort of innocent landowner.
You rely upon the certification of the waste as asbestos free,
Well,
which is what happened with Roselle. So.
Happened with Roselle, it's happened with a client of mine, and then the person who brought it in and certified it and all the rest of it disappears, and then the person who's left owning the land is left with a potentially disastrous sort of cleanup bill. We can't solve that problem. All right. Yes, Len.
So in Justice Preston's, in Commissioner Biss's judgment, she downed the application on visual impact as well. She said the mounds would be ugly and foreign element shouldn't be introduced. Did you find Justice Preston's reasoning persuasive that her findings, her wrong findings about the POEO Act, infected those findings about visual impact, which are completely, on one view, unrelated?
It's a stretch, yes, because every time she drove past there, she would see an illegally filled landfill, and the visual impact of that on her mind would be unacceptable. No, I mean, you're right. It's hard to imagine how that could infect visual. It seemed to me that visual impact surely is a standalone matter for consideration. Whether something is illegally erected or not illegally erected, it still looks the same. I would have thought, but what do you think?
No, I agree.
Yeah.
I agree.
You could have a wall that is of legal height and construction, which is still visually, offensive, but everything else about the application being lawful doesn't fall into there.
Exactly. Just because something's lawful doesn't mean it's not ugly. and the converse is also true.
I just can't see how her findings on the POEO Act and that jurisdictional thing could have affected that.
I'd love to hear how.
Liam's speaking from personal experience
want-
because he was involved.
Do you want to disclose the act of the council with litigation about
Yeah. Yes, that's right. But we've been.
I'm not familiar with the case, but was there ever any, did any of the cases deal with whether or not it should be referred under the CLM Act as contaminated land? Like, did it hit those thresholds that would have required a duty to report and bring in the EPA that way?
Not really.
just telling tales out of school, the EPA had been urged to take action for years and did nothing, effectively. So
That doesn't sound right.
Yeah.
So I don't know the answer to your specific question about how they framed that, but the EPA was certainly made aware of the issues.
In circumstances where, sorry, this is just another thought bubble, where if the EPA is determined not to commence a prosecution, it's open to other agencies to prosecute under the POEO Act. So council could have theoretically I guess that's the trigger of.
Well, the council did. The council commenced numbers of proceedings, a lot of class 4 proceedings, and were there class 5 proceedings as well? I can't remember.
I can't remember.
There was a series of different proceedings over the years. There were certainly a number of class 4 proceedings seeking orders for remediation and restitution.
And of course, they're the easier avenue to take to get those kinds of orders. So council, in a way, took the part of least resistance. But the deal in the case that we were talking about was that they would remediate the land if they didn't get consent within 6 months. And that presumably has been extended because it's now been remitted to a new commissioner. It's quite interesting because all the EPA Act can deal with, because this bill's been brought unlawfully onto the site, all it can deal with is the future use of the field. It can't retrospectively approve it. And so, I mean, one of the strategies they took in the matter that we were in was to build an equestrian centre on top of the field. And of course, when you've got an equestrian centre on top that's approved, how do you require them to remove what's beneath it? You simply can't.
The equestrian centre being a carefully selected piece of land use, which required an enormous flat platform.
We did win that one.
We did win. Yes, we did win that.
How is the equestrian centre?
The equestrian centre DA was refused, wasn't it?
Initially, I
don't know what happened after.
Yeah.
Ultimately, it was approved, wasn't it? At one stage, I think I facetiously said, given that we're now 7 metres above natural land and the equestrian centre is another 7 metres of these horses Pegasus, they need some sort of clear landing platform to get in from the sky.
Look at this horse just directly through there.
There's
Yeah,
also
there is.
Right, any more questions?
I think there are drinks and probably food. I don't know if there was food.
I don't know if there's food. There's certainly drinks. So
I'm
thank
sorry,
you all.
I've overpromised.
I'm not sure.
Understood.
Well, thank you all for coming. See you next year.